Friends, Supreme Court passed judgment in NN Global Mercantile Private Limited versus Indo Unique Flame Limited and others in the year 2021. And thereafter, the same judgment has been referred to larger bench. Larger bench of Supreme Court passed the judgment by 3:2 majority in 2023. The issue before the larger bench was whether the statutory bar contained in section 35 of the Stamp Act 1999 applicable to instruments chargeable to stamp duty under section 3 read with the schedule to the act would also render the arbitration agreement contained in such an instrument which is not chargeable to payment of stamp duty as being non-existent, unenforceable or invalid pending payment of stamp duty on the substantive contract instrument. This was the issue before the larger bench of Honorable Supreme Court. Honorable Supreme Court decided the same issue in 2023. What Supreme Court held is the view taken in SMST estate as followed in Garware as to the effect of an unstamped contract containing an arbitration agreement and the steps to be taken by the court represent the correct position in law as explained by us herein before. NN Global was wrongly decided. This was the previous NN Global judgment which passed in 2021. Court held that judgment was wrongly decided when it is held to be contrary and overruled SMST estate and Garware judgment. The court further held an instrument which is accessible to stamp duty may contain an arbitration clause and which is not stamped cannot be said to be a contract which is enforceable in law within the meaning of section 2(h) of the Contract Act and is not enforceable under section 2(g) of the Contract Act. An unstamped instrument when it is required to be stamped being not a contract and not enforceable in law and cannot therefore exist in law. An arbitration agreement within the meaning of section 7 of the Act which attract stamp duty which is not stamped or insufficiently stamped cannot be acted upon. In view of section 35 of the Stamp Act, unless following impounding and payment of the requisite duty, necessary certificate is provided under section 42 of the Stamp Act. Court further held that the provisions of section 33 and the bar under section 35 of the Stamp Act applicable to instruments chargeable to stamp duty under section 3 read with schedule of Stamp Act would render the arbitration agreement contained in such instrument as being non-existent in law unless the instrument is invalidated under the Stamp Act. Although the majority view appreciated a court in an application under section 11 of the Arbitration Act is only required to examine and ascertain the existence of arbitration agreement. What was the effect of section 6A, insertion of subsection 6A in section 11 of Arbitration and Conciliation Act? Court has to see only existence of the arbitration clause, thereafter refer the matter to arbitration. But the issue arises if the agreement is deficiently stamped and required to be stamped but deficiently stamped. In that case, this judgment will apply, this law will apply. According to this, Under Section 11 of the Arbitration Act is only required to examine and ascertain the existence of an arbitration agreement. It was held that an unstamped under-stamped agreement is effectively void and therefore the test of existence does not stand satisfied. This was the effect when agreement is deficiently stamped. Going a step further, it was also held that court acting under Section 11 of the Arbitration Act is duly bound to act in terms of Section 33 of the Stamp Act and impound the unstamped contract. It was clarified that court could proceed further with the Section 11 application only once the defect in payment of stamp duty is cured. Means court will not proceed further. Court will impound the agreement and proceed further with the application only after deficient stamp duty along with penalty paid by the parties. This was the majority judgment. What was the minority judgment? As per minority judgment, the examination of stamping and impounding need not be done at the threshold by a court. At the pre-reference stage under Section 11 of the Arbitration and Conciliation Act, minority judgment said that the deficient stamp duty should not be decided at the time of referring the dispute to the arbitration. The minority judgment further held that non-stamping, insufficiently stamping of substantive contract would not render the arbitration agreement non-existent in law and unenforceable or void for the purpose of referring a matter for the arbitration. Garber is wrongly decided. An arbitration agreement should not be rendered void if it is suffering a stamp deficiency, which is curable defect. As per minority judgment, if stamp duty is deficient, that is curable defect, and this issue should not be decided at the time of referring the dispute to the arbitration. It may be referred if there is existence of arbitration clause in agreement, and thereafter arbitrator will see whether the agreement is sufficiently stamped or not. If there is any deficiency, then arbitrator will impound. As per the judgment, there is also power to arbitrator to impound the agreement and proceed further only after the payment of the deficient stamp duty. This is the law after NN Global regarding the deficient stamp duty in any agreement. Friends, we will discuss in our next video any new legal position in Arbitration Act. Friends, if you think this video is informative, kindly like and subscribe my channel. Thank you.